America's ugly history of slavery, racial violence, and discrimination permeates throughout its law books. Cases like Dred Scott versus Sanford and Plessy versus Ferguson remind us of the painful past. Hansberry versus Lee does too, but it's also important because it laid out the due process limitations on the reach of res judicata. In 1927, white members of several Chicago communities entered into a racially restrictive land covenant. It prohibited owners of all residences within the covered neighborhoods from selling or renting to African Americans. But the covenant only became effective if 95% of property owners signed it. The covenant was filed with the Recorder of Deeds, with a certification that the 95% requirement had been satisfied. A few years later, a state trial court in Burke v. Kleiman considered a challenge to the covenant. Both parties to that litigation stipulated that the covenant had been signed by 95% of owners and was therefore valid as an initial matter. However, the defendant argued that changed circumstances had rendered the covenant unenforceable. The court rejected that argument and instead entered judgment upholding the covenant. But in 1937, Carl Hansberry, an African-American real estate broker and civil rights activist, managed to buy a home in a Washington Heights neighborhood covered by the covenant. Anna Lee and other white homeowners sought an injunction enforcing the covenant against Carl Hansberry and the homeowner who sold him the house. Lee's complaint alleged that the covenant had been signed by 95% of the owners and was therefore enforceable. But Hansberry and his lawyers proved that only 54% of owners had actually signed the covenant. By its own terms, the covenant shouldn't have been valid to begin with. The trial court agreed, finding that the Burke litigants had lied about the signatures. Nevertheless, the trial court held that the issue was res judicata, or already decided, since the Burke court had already ruled on the matter. The Illinois Supreme Court affirmed, and Hansberry sought review by the United States Supreme Court.